Hey guys, my name is Scott Shoemaker and I'm an estate planning attorney here in Cedar Rapids, Iowa. And one of the questions I get from clients quite a bit is, well, I already have a will, and so I'm done, right? Estate planning is done. I've checked it off my list. And I want to take a second and talk about that and how that's kind of a dangerous notion, and for several reasons. First, I want to just sort of set aside the myth that estate planning is a one and done thing. You write a will maybe sometime in your 30s, and or if you're really thinking ahead, sometime in your 20s, and that will is going to be good for however your life changes moving forward. And that's kind of a dangerous way of thinking for a number of reasons. The first of which is there are lots of changes that happen in our lives that we don't necessarily expect. The death of a spouse, divorce and remarriage, having children, substantial changes in our own financial situation that all need to be carefully contemplated in any estate planning documents that we may have, including a will, right? Or even a situation where a child may predecease us, right? We want to think about how our will and our estate planning documents handle that. And so a person ought to revisit their estate planning documents probably at least once every 3 years, and maybe even once a year. Go back and just make sure that there aren't any surprises that have come up between the time the will was drafted and the present situation. The other problem with relying solely on a will is that there are two problems. One is that a will only gets the job kind of half done, in terms of it leaves the estate potentially vulnerable to things like inheritance taxes, estate taxes, and other things, and a long, expensive, difficult probate process that might be avoided if we use other estate planning tools. And I would encourage you to talk with an estate planning attorney about the possibility of things like a living trust or other estate planning tools that might minimize tax obligations and things of that nature. But the bigger problem, and especially if you have children, even if you don't have a lot of stuff, even if your estate, so to speak, is relatively small, if you have children, it's very dangerous to rely solely on a will, because a will only kicks in when you are dead. And I know that's sort of a difficult thought to wrap your head around, but if you're incapacitated, if you're in a serious accident and you are incapacitated, the instructions you leave in your will are not going to kick in. And so those around you will need to rely oftentimes on sort of their best judgment, their best guess for what you would want. And so a will doesn't get the job done all by itself. There are other documents that are important to have in place. Things like a healthcare power of attorney, durable power of attorney, advanced healthcare directives, and children's protection plans that ought to be in place in addition to at least a will to round out that whole package. So even if you don't have a lot in assets, you want to really think about creating a legally binding document that will provide for your children, if you have children, in the event of incapacity, not just in the event of your own death. So again, the will, it only gets you partway there, and I encourage you to talk with an estate planning attorney about the other options. And as always, thank you so much for listening, and we will talk to you again another day.